Mr. Buller. I was a student intern just on the brief.
He has graduated and can no longer appear, so you get me instead, Your Honor.
All right, well, he did a very nice job. Let him know.
May it please the court? This case should have been a routine application of Strickland versus Washington ineffective assistance. This is a case about alleged errors that were committed by an attorney. This is not a case where the attorney was absent or where the attorney did nothing. This is a case where the defendant, the applicant's complaints, are that he doesn't like some of the things that the attorney did. The law draws a very clear distinction between the category of attorney errors and the category of an absent attorney. In this case, we're clearly talking about things where the Court of Appeals, in their opinion, and the defendant in his arguments disagree with some actions taken by the attorney. The complaints are essentially, he could have done a better job. We don't like the questions he asked. We wish he would have done more. That's what this court, the Court of Appeals, and other Iowa courts have dealt with for decades within the confines of a two-part test.
Let me ask this. It is true that this is not a case where counsel was absent. I mean, he was physically there and was asking questions and called at least two witnesses. But I found a handful of cases as I was looking around where counsel was in fact present, but really didn't perform his role in the adversary system. We're not talking about a missed point on search and seizure or a bad evidence ruling. We're talking about, well, no cross-examination, calling witnesses that were in fact adverse to the defendant, admitting guilt on closing argument and so forth. Now, it seems to me that there may well be a case, albeit it can't be an ordinary ineffective assistance. I mean, frankly, you got me that far. But I'm pressing you to the limits of that principle. And it seems to me the mere presence of counsel at PCR, in and of itself, might not be enough if the court came to the conclusion that there wasn't a meaningful adversary testing. You want to take me on or help me, give me some guidelines on how we'd approach that matter?
There are a couple different distinctions I would draw. First, I think the argument is stronger in a criminal case with the examples you give of conceding guilt during a closing argument. In that case, we're probably talking about that second basket of structural errors when a criminal defense attorney does not subject the prosecution's case to adversarial testing. Of course, in a post-conviction case, there is no prosecution. The burden belongs to the applicant rather than the state. So I think it's hard to analogize those cases.
Could you have fair point, but at a PCR, could you have a lawyer just kind of turn up and call the trial lawyer and just say, well, were you the trial lawyer here? Yes. What did you do? Would you explain to the court why? And they say, thank you very much. Does that have the potential, at least, of being a structural error?
That hypothetical is hard to deal with because that's not the facts we have here. Here we have a 137-page transcript. But maybe if I can try to take a swing at answering, what we have in Lato is maybe closer to what I would accept as at least an arguable structural error. Is there a physical lawyer that is appointed to the case on paper? Yeah, that was true in Lato. But that 1.944 deadline came and went with no action whatsoever. The language this court used was that the attorney stood mute while it happened. That, I think, is at least a much more sympathetic argument. It gets you closer to a structural error if the attorney is in the room and does nothing. If the attorney conducts an examination that we think could have been better or should have been done differently, that is the kind of routine attorney error that we're examining in the context of Strickland. Is there a breach of duty? Did he act outside professional norms? And then on the back end, is there a reasonable probability of a different outcome?
I agree with all that, actually. But when I looked at the transcripts of the questioning of the prior lawyer, it didn't seem sharp. A lot of open-ended questions, and some of the questions, in fact, reinforced the state's position. This is kind of a subjective comment, but I'm just reading it. I wasn't completely sure that we were getting a test of what actually happened at trial. I mean, it seems to me, at one level, a mere pro forma presentation of a PCR may well be a structural error. And I'm a little troubled by aspects of the record, particularly the examination of the lawyer, the prior lawyer. Let's talk about some of the specifics, maybe. The question of the representative makeup of the jury, for instance. The lawyer was mistaken, I think, in thinking there was no objection made. There was an objection made. And quite frankly, it struck me as very poorly developed in the PCR. And that's only representative. I mean, as I kept on going through, I kind of thought, oh, man. So you get the flavor, and please respond.
I do think part of the issue, as your question identifies, is there is a subjective component to reading a cold record. Anytime we're talking on appeal, it's not like we're in the room. I think some of the questions, particularly those the Court of Appeals identified, those were legitimate trial tactic strategies by the post-conviction attorney. He knows that the first assistant county attorney for Scott County is in there. She's very experienced. She's done a lot of PCRs. If he doesn't ask the defendant's original trial attorney if there was a tactical reason for some of these choices on direct examination, obviously the state's going to ask that on cross-examination. It's trial tactics 101, stealing the thunder from the other side. So without the tone of the question, I think it's easy for you to read something very differently than I would read it in this circumstance. To sort of play a little bit off of the specific misremembrance or misstatement that the post-conviction attorney made about makeup of the jury, that's exactly the kind of Strickland error that we've been talking about. That's a mistake by a lawyer. So we're talking about the first prong, breach of an essential duty. Is that mistake breach of an essential duty? Maybe. We could ask that question, but we shift a reasonable probability of a different outcome. On the record, Ms. Ruggiero, who's the original criminal trial attorney, said that she had no evidence of any systematic exclusion of persons of color on that jury. That necessarily means that there is no reasonable probability of a different outcome because the third prong of the test couldn't have been satisfied. That's, I think, why the defendant in his brief admits that he cannot prove prejudice on this record. It's impossible for him to do so.
Sure, because the record is next to non-existent. There could have been a claim that trial counsel was ineffective for not developing the problem of lack of representative. I mean, she said, as you say, she said, I didn't have anything. Yeah, did you look? What did you do? Did you contact the clerk? Did you get the jury array for the past 2 years, et cetera? Well, we don't have that at all. And then when I look at the briefing, I mean, comment on the briefing struck me as, I'll just say odd.
It is not excellent.
Well, it surely isn't. And everybody has different styles, surely. But one could argue, and we're probably going to have some argument, and we'll cross-examine the other side too, of course. But you didn't see authority. You didn't see any development of. I mean, I'll just say. I mean, it seemed like stream of consciousness and bullets, and does that strike you as what we expect of lawyers generally?
I think it should trouble you less than it does for two reasons. The first is that what the district court asked for was the framework to organize things. That, I think, is largely what we see in that brief. You see that as the post-conviction trial went on, the trial judge was really trying to do the best that he could under Gamble to identify each of the issues and get a ruling out on it. At one point, the judge is numbering the issues off to try and make sure the applicant, the applicant's attorney, the trial attorney, the judge, and the state are all on the same page. The unspoken reality in a lot of these post-conviction cases is the reason there is no evidence of prejudice or of breach of duty is that there is no evidence of breach or of prejudice.
Are there PCRs where no brief is filed at all?
Many,
There's
in
just a
fact,
trial?
most, I believe there is no briefing. I can tell you I have tried PCR cases. When I offer to file a trial brief at the conclusion, I have generally been met with surprise by the judge, and he says, well, if you want to, you can, but usually I just rule based on my notes. I would say from what we see on appeal, the overwhelming majority do not have briefing in the sense that we would talk about it on an appeal. Generally an application, an answer, a contested trial, sometimes some motion practice, and then the judge does a ruling based on his recollection and notes from the trial. I want to talk just a little bit about some of the specific issues and maybe why it's not surprising that the post-conviction lawyer was unable to develop some of these claims. There's about 10 to 15 pages in the transcript where there's a lot of talk about time cards from the machine shed. The assumption that the Court of Appeals made, that the defendant's briefing makes, is that these were exculpatory. They were out there. They could have proven the alibi. Of course, the cross-examination conducted by the state establishes he was not working at the time that the agreement was made and the crime was committed. That's additional minutes of testimony that Ms. Devine, the county attorney, examined Ms. Ruggiero about. There's a lot of talk about maybe there's some videos out there of some kind of interviewed statement of Emma Beadle. She was one of the witnesses to the agreement. There's no reason to think that exists in the first place. The only person to have mentioned it is the defendant, and he can't identify when it was, where it was, who was there. There's talk about a squad car video where allegedly the defendant and his brother are in the car at the same time making statements. The state's cross-examination of Ms. Ruggiero establishes that didn't happen. They were picked up at different times and arrested differently, separately from each other. The reason there's no evidence to support most of the claims in this case is because that evidence doesn't exist. There were 34 claims of varying nature, of varying degrees of coherency. I think I will put it politely that way. There's no evidence to support them because it doesn't exist. And most importantly, if there is a legitimate claim that post-conviction counsel was ineffective under Strickland, breach of duty, reasonable probability, this court in Allison said he can file a second post-conviction application. This court said in Good that a remand is not appropriate. If we're worried that post-conviction counsel missed something here, and I can tell you from my reading of the record, that is not a concern I have, but maybe members of the court have that concern. Allison provides a solution. A second post-conviction application can be filed, and the Court of Appeals decision in this case, this adoption of a new flavor of structural error, is just unnecessary. It's untethered from the precedent, and Allison provides an adequate remedy if the court is concerned about the quality of PCR representation. I would ask this court to affirm the denial of post-conviction relief and vacate the Court of Appeals opinion.
Mr. Bowler, thank you. Mr. Tindal.
May it please the court. Counsel. The existence of Allison and Good do give me some solace that no matter the ruling here today, that my client will have an avenue of relief. Before I end my discussion, I would ask the court to clarify a few things between Allison and Good for us practitioners in the world in terms of timing. But I'm not here to give up on the structural error issue just because Allison and Good exist. I've been born and raised in Iowa. My father is an attorney in this state and has been since the early 70s. I have never been prouder of this state than reading the opinions where this court talks about this state's pride in assuring fairness and justice in this state and extending that law even when federal precedent hasn't guided us there. I think in the recent Schmidt case, Justice Cady's concurrence notes that the Schmidt opinion was a reason to stand tall and walk down a little further the road to fairness and justice. And so I'm here to ask this court to do that when it comes to structural error. Justice Apple, as you pointed out, there aren't that many cases on structural error where an attorney has been present and done something. Williams was, the Court of Appeals decision here was somewhat of an extension of that principle. But I think that principle comes from the language in Lado that talks about what structural error, when structural error occurs. So structural error occurs, according to Lado, when counsel is completely denied actually or constructively at a crucial stage of trial. Or where counsel does not place the prosecution's case against meaningful adversarial testing. In the area of post-conviction relief, it's really not the prosecution's case we're looking at, it's the prosecution of the case. So in post-conviction, I would argue that structural error occurs where counsel does not meaningfully prosecute that person's case.
Well, that may be, but I'd like you to respond to Mr. Buller's line of reasoning, which is of the 34 assertions, or however many there were. If you look through some of them, it is true that there was no evidence in the PCR record on police video and a number of the other issues. But of course, there might have been no evidence that was helpful. It may well be. I mean, we can't tell from the record as we go through a number of the claims. I mean, I know there's an assertion, ABC, that the prisoner wants to assert, and you point out, and the Court of Appeals point out, that there was no evidence at all on the record, which is true. But of course, there may have been no evidence to support it. We don't know at this stage. And so isn't it a little hard to say, well, I mean, on the one hand, we can attack counsel by saying he did nothing. He didn't introduce the police video. He didn't introduce this. He didn't introduce that, and so forth and so on. But as far as we know on this record, there may have been a good reason he didn't introduce it because it wasn't helpful.
It's a fair point, other than, I guess instead of looking through the transcript and the questions and answers, I think the better evidence of the issues here are actually in the March 7th, 2017, what he captioned supplemental to 34 pro se trial issues. It was called a brief, but what that does is it cites an issue, it cites what counsel should have done, and then the prejudice that arose. I would assert to this court that although it's presented in the way this is what trial counsel should have done, it's equally applicable to what this trial counsel should have done. These are not rocket science type issues. A clear example of that is there's a claim that there was a relationship that was somehow other than prosecutor-witness between the Scott County attorney who prosecuted the case and the state's clear key witness in the case, Emma Beadle. Curiously, the very same prosecutor who did the trial, who may have had this unusual relationship with that key witness, defended the action for the state in the post-conviction action.
You're assuming there was a relationship.
Well, we do know there was something, but we only know that from Ms. Devine's cross of the trial attorney, where she basically indicates in kind of a leading question, don't you remember me telling you that she was a prior victim in another case? And trial counsel I suggest, doesn't really strongly answer that she remembers. It was essentially, oh yeah, now I remember that now. So there was something there. We can't know what it is, but I think a reasonable post-conviction attorney would have deposed the prosecutor, which certainly could have raised the issue of conflict for that same attorney representing the state in the post-conviction.
How do we know the attorney didn't interview the officer?
The attorney didn't interview the officer or the prosecutor?
I'm sorry, the prosecutor, yeah.
Well, we have no record either way. I would suggest the record that's there suggests that it probably didn't happen. At least I think it's a reasonable assumption. And obviously, I think there can certainly be close cases, close calls. I think best practice would be if the attorney did something to look for the evidence and it wasn't there, there should be a record that this is what I did and it wasn't, we were unable to locate it or whatever.
Let me ask you another question. I mean, one of the problems in these kind of cases, I think you have a pro se defendant that has, multiplicity of claims. You've got a lawyer that's trying to deal with the pro se defendant. A good proportion of the claims are often not well-founded and based on misunderstandings of both law and fact. But under our case law, the Gamble case in particular, the counsel has to be kind of careful about what he concedes and what he doesn't concede. And so the lawyer in this case arguably was juggling a little bit. Had a percentage of claims that the lawyer felt were specious, and decided the way to handle that would be just to interrogate the client and let the client kind of make the case. And that was kind of a uncomfortable but maybe satisfactory resolution of the problem. What makes you think that wasn't the case here?
I think what makes me believe that wasn't the case here is because there's just no indication of that. I think the strong conclusion that can be reached from this record is that PCR counsel essentially kind of mailed this in.
Well, let me ask you a question. Did you talk to PCR counsel when you were appointed to represent Mr. Williams on appeal?
Well, no.
Why not?
Because I'm limited to the record that's made. I can't add to that record based upon my interview of Mr. Standifer. At least that's my understanding. I'm not sure how it would supplement the record with additional evidence on those issues.
I just asked because normally when I was appointed to an appeal, I would pick up the phone and call the person who had handled the proceeding below.
You know, I guess that's a fair question, and maybe I should have done that. I can only answer to the court that I didn't do that in this case for a couple different reasons. One, I am familiar with trial counsel and am familiar with kind of sort of a broader record than the one that appears here, and I don't think it would have been a productive conversation. Two, I don't know how that would have helped me address these issues when the main issue that's here is there's an absence of record on essentially every claim that this applicant wanted to raise. And I agree that in many of these PCRs, you get a flood of these questions and issues, and 10 out of 11 of them could just be, you know, baseless or hopeless, whatever. But that one issue is important.
Sure, but that could be, I mean, if there is that one issue there, that could be aired in an Allison-type hearing, I imagine.
Let me ask another question. You know, we have a procedure under Rule 61005 where attorneys can essentially bail out on an appeal completely. Is that a structural error?
Well, and that's the frivolous rule.
Is that an unconstitutional procedure?
Well, as part of that rule, the trial counsel can't, or appellate counsel can't just bail. They have to brief what they believe the issues would be. And typically, at least for me, I haven't done those in a long time based upon practice.
But they're doing what, in essence, you sort of say the PCR attorney here did. They're arguing why why those issues are not valid, or why there isn't an issue or a basis for an appeal, right? Well, isn't that kind of the same thing?
Well, two things, Your Honor. First is that for quite some time, the practice as I've understood it is that you will be filing a brief. And so I think there's some tension in the rules about that, but that's been the practice. But number two, appeal is different because there's already an evidentiary record made. Whereas you're limited to that record. That record is what it is. It's kind of the four corners of the record. But when you're at the trial level, especially in post-conviction, that's where evidence gets submitted, evidence to be considered. So I'd say the difference lies in the fact that if appellate counsel uses the rule to withdraw from the case, that doesn't mean that this court doesn't get a full view of the record that was made in rendering its decision. Whereas when the trial attorney bails in that way, there is no record for any of us to review.
Well, let me put this hypothetical to you. I think you'd be on strong ground if the following facts were true, that PCR counsel The record shows did absolutely nothing prior to the hearing other than secure the attendance of the trial lawyer and client, I guess. Didn't open the file until the night before, or maybe not even the night before, and came in and winged it. There, it's almost like the Scottsboro boys and everybody out in the crowd being appointed the day of trial. There, the lawyer might be there and he might have structural error because you could show that there was no preparation he wanted, and he couldn't possibly do a meaningful presentation given the short time frame of studying the file. But we don't have that here. I mean, we know that there was an appointment. We know that 1904 was avoided. We have no idea, correct me if I'm wrong, but we have no idea what's underneath the surface of counsel's work on all these claims.
Well, all of these cases are on some kind of a spectrum. And certainly you can have the worst case scenario where we're pulling a real estate attorney out of the crowd to handle a murder case. And so I wouldn't say this is that. But I don't think it should require that level of error to create structural error. Certainly wasn't that level of error that was found to be structural error in Krogman that was recently decided. The attorney in that case did a lot, including file for an interlocutory appeal of the order to freeze assets. But there was still structural error found in that because that attorney didn't challenge the district court on it.
Counsel, if we allow the Court of Appeals decision to stand, or we bless it, are we into a new world of structural error whenever there's PCR counsel could have done a better job, and you've got Supreme Court justices with all the time in the world second-guessing a busy PCR counsel and saying, I don't like this cross, or you didn't follow up on this? I mean, where do we draw the line between a could have been better to mediocre to so bad that it's structural error and you don't have to show it would have made a difference?
I would answer that as it's always the challenge. It's always the challenge between efficiency and the potential for justice. I see I'm almost out of time. If I could have slightly more time to completely answer the question.
You may.
So in Allison, that was part of the concern from the dissent, that we're going to open this all up to all these new challenges. I think that kind of where that starts is it starts with the principle of when is it better for 10 guilty to go free than 1 innocent to go to prison? That's kind of the base where it starts. Now, with respect to that, you have to have some kind of range in there where you got to have some finalization. There is an interest in finalization for the state and victims in cases. But all of these cases ultimately are decided on their own facts. Whether you set the rule in one place or not is still going to be challenged. Structural error is still out there for all these cases. But I think that really what I'm asking this court to do is to say that doing something that really is nothing is not enough. Do your job. It doesn't mean you're always going to be successful. It doesn't mean that all that energy is going to be well spent or meaningful. But in the cases where you do, and you do discover these issues, that means a lot. That means a lot to the system of justice. That means a lot to the state of Iowa. Thank you.
Mr. Tindal, thank you as well. Mr. Buller, you may present your rebuttal.
I want to start by answering Justice Waterman's question about what happens if the Court of Appeals decision in this case stands or receives a blessing from this court. And I have a lot of concerns about the Court of Appeals opinion. There are two that I think are the most important. First, the language the Court of Appeals uses is that the attorney in this case was, quote, a less than zealous advocate, and they equate that to structural error. In a room full of appellate judges, I'm not sure there's any case where you could review a trial transcript and not find something that you might Monday morning quarterback or think, if I was there, maybe I would have answered or asked this question differently. That's the nature of busy trial practice. It cannot be that every time we disagree with or think maybe a different approach would have been better, it is automatic reversal. My second concern with structural error, the way the Court of Appeals has described it, is that if it is true that every time the court thinks that a trial attorney could have done better, it is structural error, then we all have a lot of ethics violations we need to start reporting, because this court has said that rendering ineffective assistance is an ethical violation. It's faltering in the duty of competence.
Agree with all that completely, frankly. Yet, I think the Court of Appeals came to the conclusion, after looking at the record, that the lawyer basically showed up, but did not do a meaningful adversary test. I mean, the Court of Appeals, there's language that you're picking up out of the Court of Appeals that did focus on zealous advocacy and so forth. And I certainly understand your position that just because you would have asked a leading question, you know, fair enough. It depends on style, a lot of things. But as I read the Court of Appeals opinion, between the lines maybe, I mean, they're really saying just showing up is not enough. That seems kind of right. Now, the record might not establish just showing up. I mean, it establishes showing up, but we don't know, and I'm kind of sympathetic with some of your discussion, like on the police video. I mean, you know, we don't know. But it seems to me that there may well be some occasions where the lawyer is actually present and you know, kind of doing his job. I mean, but failing to adversarially test the system. That wouldn't offend you, I don't imagine, if it was sufficiently egregious, I suppose. And
I can leave room for an extreme hypothetical, you know, the Powell case, we're yanking somebody out of the audience. I think everybody agrees in that scenario, if there is a constitutional right to counsel in that situation, and we know that issue isn't resolved in Iowa yet, but if there is, I think we all can agree there is an extreme set of facts that probably would trigger structural error if it's a constitutional right. I suggest to you, you don't even need to go that far down the road here, because this record is so far from those facts. This is not an attorney who sat there and did nothing, who let the case be dismissed. 137 pages is a long record for a post-conviction trial. This is pretty thorough questioning. Would I have maybe asked some of the questions differently? Yeah, sure. That's every single record I've ever read, including my own when I read them in a transcript. I think I could have done a better job. That's the nature of trial work. What we have here is a fairly thorough examination of the issues, and for all we know, the reason there was no evidence presented on many of these claims is because there is no evidence to present. And again, I suggest if we're worried about it, the easy answer here is vacate the Court of Appeals opinion, affirm the denial of post-conviction relief, and the defendant can file a second PCR. We can litigate some of these unanswered questions and find out if there is a reasonable probability of a different outcome.
Well, let me follow up in that area. I mean, as I read over this 137-page transcript, the one thing that struck me as a little unusual, and Mr. Tindal, I think, referred to it, is this testimony that came out about some kind of relationship between the prosecutor and E.B., the main witness against Mr. Williams. What's the record on that as far as you know?
There are vague and not credible assertions by the applicant about some kind of relationship. And the reason I say they're not credible is that's not my judgment. That's the post-conviction court's judgment. Page 2 of the post-conviction order, quote, the defendant was not credible. Page 4, the court doubts the petitioner. That's repeated twice on that page. What we often see in these cases is that an applicant has either a misimpression or a misunderstanding, willful or otherwise, about what has transpired while they've been incarcerated. Obviously, the applicant in this case thinks there was some kind of secret relationship, conspiracy, something between the prosecutor and the witness. There's no evidence of that. The post-conviction court said that there was nothing improper about that relationship. I think that's a fact finding even. Then we have 2 fact findings directly on the credibility of the applicant. There is no reason for this court to be concerned about that issue. But again, if you are concerned, there's an easy answer. That's a second post-conviction application. I would ask this court to affirm the district court and vacate the Court of Appeals.
Mr. Buller, thank you very much. Mr. Tindal, thank you again. The case of Williams versus State is now then submitted, and the bailiff may adjourn.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.